and I think it's important that we put it on record. When it comes to the interpretation of our Constitution, we even have the lawyers disagreeing. We even have the Supreme Court judges themselves usually disagreeing on what they believe the law says. And so we shouldn't really restrict this conversation to Mr. Domelevo and the president. I think that's, for me, immaterial. What is important is that we have a Supreme Court that is really working to shape our governance and our democracy. And for me, I think that is, for me, is very crucial, that as a country, we always have a Supreme Court that we can run to seek clarity on issues where citizens disagree on. I mean, Honorable Baba Jamal, like you said, if I go and sit in Honorable Mama Jamal's seat as a deputy local government minister, I look at how Honorable Baba Jamal probably set up his office when he came, the sort of letters he wrote, how he wrote it, because he probably would have been there earlier than I, and so would have referenced certain statutes to take decisions. You look at it, if you believe that how Honorable Baba Jamal did it, it's fine. You just move on from there and then you proceed. Within that space, you would always have other people who would disagree with you. I think the decision to agree or disagree with those people doesn't lie between or amongst you. That is why the Supreme Court is there. That at any point in time as a country where we have some ambiguity, so to speak, or disagreement on any aspect of our laws, we can run to them for interpretation. I mean, if you look at the wording of the letter that Mr. President wrote to Honorable Mr. Domelevo, it's almost like verbatim to what Professor Mills wrote to Mr. Dua Ajimai. And the President believes that that is not in contravention to the law. And then lawyer Martin Kpebu disagrees. You understand? So the back and forth, so Domelevo writes, Mr. President responds. That is all part of the building the governance system. Now that the Supreme Court has ruled, now we have a law. Because for me, I can always say that this was a gray area in our law. In as much as I believe it's right, another person believes it's not right, it means that it's a gray area. Now the Supreme Court has made a very emphatic pronouncement on it, and it becomes law. So if in the future, Honorable Baba Jamal becomes president, he can no longer do otherwise. Oh, I'll be happy. Maybe you are from Eastern region, and so I'll be happy. Yes. The best come from the East. So after you realize that no other president can do otherwise, because now there is a law. Once there's a pronouncement from the Supreme Court. So I think for me, this conversation is more about applauding the individuals and organizations who took up this matter, applauding the lawyers who took up the matter, to go and seek clarity. Nana Danko Akufo-Addo and Martin Domelevo were not on trial. They were not on trial. It is a constitutional interpretation that was being sought from the Supreme Court. And I think that is the way to go. It is the more reason why a lot of us, when we are engaging in such conversations, we always say that, listen, we should allow the Supreme Court to do their work. There are days that they will take decisions in your favor. There are days that they will take decisions against you. But at all times, let us protect the sanctity, the dignity, and integrity of the Supreme Court. It is okay if you have a one line that says, I disagree with the Supreme Court. There's nothing wrong with it. But immediately we move into the arena of trying to denigrate them because they have taken a decision that we don't agree with. Then we are causing problems for ourselves and even causing credibility crisis. Because the truth of the matter is that, lawyer, there are a lot of very renowned people in this country that when I follow their commentary on this particular ruling, it throws their credibility into the air because of some of the comments they have made on past judgment by the Supreme Court that didn't agree with their opinion and views. You understand?
It's normal but the court is bad.
Exactly. But it is also really good when it happens this way. So that tomorrow, when the Supreme Court rules on something else, and you begin to call them, you say, oh, this one, that's how he is. When he loses a case, that's how he behaves. So nobody should pay heed to him. But I for once think that this is because this is not the first time people have gone to court to challenge decisions of government. In the past, this happened severally. Asama Boati and Co, Akwesi Eje and Co, Reku Brobe and Co. There are several cases People have sued even institutions like the Audit Service and the Electoral Commission on their own decisions. You understand? So these are things that we need to continue to do to build. The Audit Service, for instance, I have my issues with them. I mean, anytime I see the Auditor General's report, I see loopholes and gaps. It's not as if they are some angelic institutions. They also make mistakes. Haven't we had allegations of procurement issues even against the Auditor General himself on the procurement? Exactly. You know, those are all things that individuals would always have issues on how they believe things could be done. I think that what the civil society organizations have done and what the lawyers like Martin Pebu and individuals have done is the way to go to settle public disagreement. So long as, even if it's 30 million people against you, it means that there's a disagreement. But let's always go to the Supreme Court. And when we get there, let us leave the matter to them to determine. And I like what Justice Dochi said. You realize that today, because the judgment, so to speak, has gone in favor of some people, they are no longer calling them unanimous FC and calling them names. But I can bet you, let's give ourselves the next 1 week. You see the people who will say the law is supreme, rule of law is ruling, the Supreme Court is protecting, You see them now calling the Supreme Court judges names. These are the same individuals. What I believe we should do is that the Supreme Court are human beings. They may also make mistakes. They will also commit flaws. But whether we like it or not, in the issue of constitutional matters, they are the only competent people in this country. All of us, in spite of our experience, in spite of our knowledge, once they make pronouncements, whatever we believe or think goes smooth. And I think it's the way to go.
Okay. Well, let me go back to Professor Etua. Prof, now, yes, I'll come to you. The sanctity and independence of the Auditor General. And I think Dennis Miracles makes the point that this ruling of the Supreme Court has brought clarity and settled the matter. But was the Auditor General's independence ever in doubt, even before this case went to the Supreme Court?
Well, according to the law, according to the Constitution and then the legislation dealing with the office of the Auditor General, it's not in doubt, but it is a government that placed some doubt in the independence and the integrity of the office of the Auditor General. And that is what brought about this whole mess that we had to go to the Supreme Court for the Supreme Court to clear things up for us. And it's very unfortunate that this should come from the highest echelon of governmental authority. And so, to me, it is a below-the-belt approach by the government to compromise the independence and integrity of the office, because this is a very important office in terms of governance, accountability, and promotion of the rule of law, and fighting corruption, to have such a body. And so for the government, which has all the arsenal to be able to know what is the proper state of the law, to turn things upside down is quite unfortunate.
I see. Now, but looking at the communication at the time when this was happening, and I made reference to what Daniel Domelovo said in a letter to the president, making specific reference to the same basis for which the Supreme Court ruled on this case about the independence of the Auditor General's office. And the president makes reference to sound and good judgment of the law or sound legal advice. Was there any legal basis to justify that directive or the position by the president at the time in 2020 asking Domelovo to go on leave?
No, not at all. That's why I'm saying that the interpretation or understanding put on the existing legislation on the independence of the office of the Auditor General is very unfortunate, and it creates the impression that it's as if when you are in power, you can do whatever you want, forgetting that we have a constitution and other laws, and that, as we say, Ghana is a country of laws. And so if anybody should violate the law at all, it should not be the government in power. But most often it turns out to be the other way around. So it's a big shame that this should be how things should turn out. But we thank the Supreme Court for stepping in and making sure that things are corrected. And so going forward, we are clear in our minds as to what are the limits of government. And I think it shouldn't have come to this for the Supreme Court to come in before we know where to draw the line. But in any case, we thank God that has happened. And so going forward, we hope that the government will not do any gymnastics with the law and try to do things its own way.
You were making the point earlier that this case could have been ruled on earlier than what we saw now, correct?
Yes, certainly.
I see. But in your view, what may have led to these delays? And others talk about more political considerations than legal.
Well, I mean, like I said, the rules are clear that the Supreme Court could have given an earlier decision, probably within 3 months or something, but certainly before the domino levels accumulated leave and so on would have ended. And so I think that when the court doesn't do what it has the power to do, then it lends itself for various interpretations and for the political interpretations to come into the question, and which therefore lends itself to question the independence and integrity of the judiciary. And so it's unfortunate that it turned out to be so. It is not possible to read the mind of the Chief Justice, under whose jurisdiction or under whose tenure that decision was made, or the proper decision was not made for the case to have been held earlier. And so I think that going forward, we should not, the Supreme Court should make sure that decisions that are time-bound are given on time, so as to avert or does not give room for people to interpret things differently and to say that there has been some bias and the court is under the influence of the government and so on and so forth. Some are also arguing that the court was waiting for the CJ to have gone before giving the decision. So all these issues could have been dealt with or wouldn't have arisen if the Supreme Court had acted timeously to deal with the matter when it was needed most.
Professor Chair, thank you. Please stay with me. Stay with me because we'll get into your case as well, because the Supreme Court ruled on a case that you also took to court earlier this week. Baba Jamal, on this, I recall that when there was this back and forth when this issue of Daniel Demelovo was ensuing in 2020, Eugene Ahin also wrote a letter making reference to the fact that the president took inspiration from something that had happened in the case of Edward Diajiman while he was the Auditor General at the time in 2009. But the Supreme Court has ruled now on this matter, and that the president's directive is unconstitutional. That is it.
When those issues were developing that time, some of us were of the clear view that there was no ambiguity as to the independence of the Auditor General. There was no ambiguity at all. Because when you go to 70 in the Constitution, Article 71, and when you go to the Auditor General and it goes back to 146, there's clarity as to how to remove an Auditor General. Clarity. So I think that it is a shame that no institution like the presidency would throw us into that controversy. Because it's the presidency that threw us into that controversy. And I think it's a shame. Because you see, comparing Domolevo's situation with Ajimendua is a situation of somebody who has retired and has passed his time. That's different from somebody who is serving and yet to retire. They are two different issues. You can't compare that of Domolevo to that of Ajimendua. Ajimendua was past his days in his office and he's still occupied and somebody wanted to take him out. And this one, it is a person who is still serving. And you see, some of the developments at that time and the actions taken by Demolevu and the action taken by the presidency created the impression that the presidency wanted to just get him out. And I think majority of that's why I agree with Mr. Professor Etia that we shouldn't have come to this stage. Because when the presidency wrote to him and all the back and forth, he says he had sound legal advice in his letter. The presidency has, various institutions and lawyers, the whole of the Attorney General to its disposal. So it can have access to the best of lawyers. And I think that if it has listened to good advice then, they wouldn't have gone down the road they went. They wouldn't have gone that road because majority of the state or majority of the public was against that decision. And the Supreme Court has just come and confirmed. You see, when my brother is talking, he tries to create the impression that some people are against the Supreme Court. But let me tell you, if the Supreme Court thinks they are denigrated, they have a process of resolving that thing. And they have done it over and over and over. Criticizing the Supreme Court after a decision is part and parcel of development of law. Do you understand? Criticizing the Supreme Court after a decision or disagreeing with them is part of the development. Look, disagreeing with them and calling them unanimous FCA, now Justice Doche is making reference to that. Means that somehow they have been affected by it and they want to do things maybe better than what they were doing. It does not mean that nobody believes in the Supreme Court. It does not mean that we have any other place to run to when there are controversies. We will go to the same Supreme Court. And that is why when we're talking about education, I said, let them go back to court. We'll go. You understand? Mm-hmm. Because that is the only place you go anyway as a citizen. My point is that it is a shame we got to this point. I think that the presidency shouldn't have taken us down the road, but it's fine. It has enhanced the tenets of law. You understand? Mm-hmm. We are happy with it. But finally, I thought that the Supreme Court should have gone a step further by making some consequential orders. Because if Dominibo has lost the opportunity to come back, what is his compensation for that? Do you understand? He has lost. He was not supposed to go out. It was unconstitutional, but they took him out. What should he be given, or what is?
So you expected what? Some compensation?
I expected some orders to give him some compensation, and you see they've declared the appointment of his deputy, ACLU also, as unconstitutional. What is the effect of that? All the payments and benefits that went there, what is the effect of that? So I was expecting that the Supreme Court could have gone a step further, make some consequential orders to at least support Dominibo for the loss he has gone through, and also maybe correct certain mistakes that were done. But it didn't happen. The Supreme Court are the wisest men in the country. They have taken their decision. All what we can do is to also express our opinion. But when Martin Kwebu was speaking, he mentioned one of my favorite lecturers, Mensa Bonsu, Marieta Mensa Bonsu, and also Esiankuma. They are my favorite lecturers. In fact, two of my favorite lecturers. And even though I have some political disagreements with them sometimes, but they are my favorite lecturers because I think that I defer to some of their decisions with strong decisions. So, but we need as a country to start to please depoliticize institutions that are supposed to be independent. We need to depoliticize them. We need to get the Auditor General to do its work. Let the courts do their work. Let the Electoral Commission do its work. Let NCC do its work. Look, if we are to follow this constitution, even though with all its defects, I'm telling you, if we depoliticize it, this constitution will work for us. Yeah. If we depoliticize it, this constitution, with all the defects that is in it, will work for this country, will take us where we want to go. But it's because of our own political interferences, even look at the way we sometimes go about even appointment of some of the people to these institutions. It doesn't help the country. You see, how can, for example, one of my beef is that, how can you appoint a politically exposed person to a place like Electoral Commission? The moment you do that, you create a problem from the very beginning. Do you understand? You create a problem. Because, for example, today, if NDC comes to power and you wake up and hear that Baba Jamal is being appointed to the Supreme Court, how will you feel? How would you feel? Because I'm too politically exposed. I may occupy other positions, but not necessarily going to the Supreme Court. Do you understand? I may qualify, but there will be equally qualified people that you can appoint to take them to the Supreme Court, but not this face of Baba Jamal, which is identified with one side of the political divide, which will not help. The same way, if you today you hear me be appointed to the Electoral Commission, how will you feel? How will the other side feel? Let's be honest with ourselves as politicians, as people who have been entrusted with positions of authority, especially the presidency. And you know, I agree with you that you were scared whether you will win or lose, especially with the type of presidency we have today. Yes, because the presidency we have today does not care, don't care what he does, can do anything because they think that the people don't have the teeth to budge. That's what the type of presidency we have today. And that was what I'm not surprised you were scared. But at least we are happy that the Supreme Court has come out with its position. The position is clear. It helps for the future. I expected some consequential orders to be made, which I have not seen. I thought that it could come. But whatever it is, we have a law now. Let's all adhere to it. Let's go forward in a better situation.
It's the progressive nature of this ruling, but Martin Pebo, that bit about, because you led this case and have won, the bit about the compensation or some consequential orders. Would you?
So can say, remember I told you that. I mean, I'm sure after
anyway.
In a month's time, 2 months, 3 years from now, then I'll start commenting. But the agreement is that at least this initial stages, I should leave for you guys to deal with it.
I strongly believe that there should have been some consequences.
But you see, when I spoke to Daniel Domilovo this week, he said that, I mean, apart from this, some of the things that contributed to the happenings, he described his working environment as extremely toxic, where he had to watch the people he spoke to, the people he talked to, and he worked with, what he ate, what he drank. He had to be extremely cautious because he described the Auditor General's office as an enemy territory, sort of, and all that had happened. This is an independent institution, really, and his description of that and what had happened during that particular period. Lawyer.
Well, you see, he doesn't want to talk about it. But you see,
no, this is before. This is outside of the. It's outside of the case. This is outside of the case. It's an instrument that we have made.
You still need me.
Yes.
You know,
Those of us want to talk to him.
Can I speak for him?
Oh, how?
No, I'm speaking for him. He has asked
it's okay. It's okay. Lawyer doesn't want to speak.
Yes.
Well, there is miracles on this particular concern that he raised about it.
I think that for me, I mean, aside the concern.
And then you have been consistent
Yes,
about
aside
the
the
impact
concern,
of this.
I think that for me, anybody that tries to draw in the issues of threats to the independence of the Auditor General and politicization is just trying to do politics, that's all. Because, Alfred, there is a reason why we have the Supreme Court. And there is a reason why the Supreme Court is closed with the mandate to interpret our Constitution. There is always a reason. There is always a reason. So if we find ourselves in a situation where there is a banter, because I always believed that the decision was right. Yes, but Bajama always believed that it was wrong. Professor always believed that it was wrong. But there are several others who believe that it was right. And I keep hearing people say that, the Atamel's one was different. It wasn't different. If you read the letter Professor Atamels, the president, wrote to Mr. Duajimai, it is the same wording, verbatim. Nowhere did he say that you are retired. And so I'm asking you to take your leave because you are retirement. Nowhere. Nowhere did he say that. In any case, don't forget, Mr. Domilevo's retirement age itself had already been part of the conversation. Because the Audit Service Board had already indicated that he was supposed to have retired somewhere 1st June 2020.
Which he contested.
Exactly. See, so that is why I'm saying that we should just acknowledge that we are a country in progress. There's a governance system we are running. And so until we're able to get to the point where we've had interpretation to several issues, who says there was no ambiguity in the matter? Have you forgotten that Honorable PC appeal for it? Somewhere in 2007 or so, had to take the same Auditor General issue to court to go and make a case that the Auditor General's stay in office is almost the same as an appeals court judge, trying to make a case that the Auditor Generals are not supposed to necessarily retire at 60. You understand? So there has been other legal challenges and issues around the same Auditor General, age of retirement, independence. There are cases. And all these things are only meant to ensure that these institutions are strengthened. If I am president and I am to take a decision, I take the decision based on my understanding and interpretation of the law. The law says that if I take a decision and you disagree, you can go to the Supreme Court to go and seek interpretation. It doesn't mean that I have done anything necessarily wrong. That is my understanding of the law. Don't we have people go to court?
That is your understanding of
if
the
I
law.
am president, that would be my understanding of the law. And so if you take my decision based on my understanding of the law to court, and then the Supreme Court rules against me, it doesn't why. Haven't the president also taken decisions that others have challenged, gone to court, and the people have lost? The same Mr. Domelevo, didn't he lose a case against Honorable Osafo in court on the Crow and Associate matter? Didn't he still go after him? Is it not the court? But I remember that in that instance, when the court took a decision, the same people came and said, no, the court is wrong. How can the court be wrong in one instance when the decision goes against you, and the court is right when the decision goes for you? I am of the view, and we in the MPP of the view, that the Supreme Court is supreme. All of us actors of the state, both state and non-state actors, are only trying to put our constitution in motion and in action. We would get it right, we will get it wrong. It is up to the Supreme Court to always come in and guide us. But when they come in, we in the MPP would always, all the time, uphold the decision of the Supreme Court, whether it goes against us or it goes for us. And our advocacy now is to all other actors, both state and non-state actors, that this is the only institution that we have that is supposed to guide all of us. And so moving forward, please, today, you have won a case and you are saying all manner of things. Tomorrow, when you take a case to the Supreme Court and they rule against you, don't again come out and make it sound as if you still know more than the Supreme Court, and that even though they have ruled, you still think they are wrong. It is unfair to the Supreme Court.
Okay, but yeah, I'll bring you, Baba. Let me acknowledge Lawyer Martin. People had to leave us to attend to a situation. So he's just left us just for the benefit of our viewers. Yes, Baba Jamal, before I go to...
When Riverson speaks, he creates the impression that Supreme Court has spoken and somebody has defied it. Can you defy the Supreme Court's order? Which order has the Supreme Court given? We may criticize it. We may disagree with them. But nobody says that the Supreme Court is not supreme. The Supreme Court is the Supreme Court of this country. Please, when people are expressing contrary views to their decisions and actions, it does not. I've already told you that as lawyers, we see those controversies as part of development of the law. The law itself is dynamic. The law, that's why we call ourselves learned, because we are always learning. The law itself is dynamic, and we must continue to revise it, challenge it, interrogate it, criticize it, so that we can get better laws out there. This one, if not because of Martin Pebu and co, have taken this thing to court, maybe what the president has done, which is wrong, would have stood.
There are several like that.
Hold on. I'm saying that
because we are emotional.
I'm talking in respect of this particular that if these people, the civil society people, having gone to challenge it, maybe we would be operating with the wrong decision of the president.
If Osama,
can I finish? Can I finish? You spoke and I didn't mind.
Dennis,
when you were speaking,
Dennis,
when you were speaking, I didn't. So what I'm saying is that law is dynamic. So don't create the impression some people are against the Supreme Court. The Supreme Court is the Supreme Court. When the Supreme Court ruled that the question should be suspended, should be injuncted, what happened? He left Parliament. When the Supreme Court ruled that he should be taken out of Parliament, what has happened? So please, what we are saying is that when the Supreme Court does it right, we'll talk. When it gets it wrong, we'll talk. We'll continue to interrogate the law. Because when the Supreme Court speaks, it becomes law. And we'll continue to
So when
interrogate
it
the law,
gets it
but
wrong,
don't
in
take
your
that.
opinion.
In our opinion. I'm saying that in our opinion, if we disagree with the we'll come out with the opinion. But please don't interpret that to mean that some people are against the Supreme Court. The Supreme Court is the Supreme Court, and you cannot defy the Supreme Court. Please.
Okay, thank you. Let me bring in Professor Chia is connecting with us back on Zoom. We lost him briefly. Prof, now that point about the citizens, and just like yourself and many others who are watching us, beyond the complaint, actually taking action to test the law, to correct the illegalities and unconstitutional actions by anybody, regardless of the person's position. Because in this Daniel Domelovo case, imagine if these 9 CSOs had not put their own private resources together to get a lawyer Martin Kpebu, to go to court and then challenge this particular directive by the president. We would have been living with this. And I can imagine the number of illegalities and unconstitutional directives that, because the citizens didn't challenge it, we're living with it now. Prof, you can unmute for me, please.
Thank you.
Yes.
Certainly, there is a need for involving the judiciary as an important arm of government. And so when we have an issue, we are not clear about what the law is, that is where we go to. And there's been the suggestion that in some countries, when the issue is concerns a public interest litigation, there should be a situation where lawyers are made available to take up such matters for free, so that there will be more cases brought before the courts to improve to get a better understanding of what the law is and how it should be applied, so that the executive will not try to always bulldoze the rest of the society and do things its own way. And so it's very important that we are conscious of the need to have easy access to the Supreme Court for such interpretation, so that the executive will know the limits of its powers, and to know that if it should cross the line, there is a body there that is ready to check it, so that it wouldn't just be giving commentaries and writing articles and so on, but actually challenging the legality of such cases in courts. But I'm also proposing that the public interest litigation matters, there should be a way for lawyers to be paid, so that it wouldn't come from the pocket of ordinary persons who wants to ensure that the right thing is done.
And Prof, on that, because I know you are in motion and had to briefly stop to speak to us, we need to congratulate you as well, because you also tested the law and the Supreme Court ruled. In fact, the Supreme Court, in a unanimous decision, declared as unconstitutional the law that allowed government to impose restrictions during the COVID-19 pandemic. Parliament in 2020, if you recall, passed the Imposition of Restrictions Act to allow restrictions provided for in Article 21 of Ghana's Constitution to be imposed. The said constitutional provision allows restrictions to be put in place in the interest of defense, public safety, public health, and so on. But Professor Appiah-Jaitua, you were convinced that this directive, in fact, this law that was passed and approved by Parliament was unconstitutional, and you took this matter to the Supreme Court. Why exactly?
We took that matter up because we realized that Ghana has enough laws to deal with emergencies. We have the Constitution under Articles 31 and 32 in particular. And then we have the Emergency Powers Act, which is derived from Articles 31 and 32 of the Constitution. And we also have the Public Health Act. All these three instruments or laws have the wherewithal to help deal with an emergency, including COVID-19. Because, for example, if you look at the definition of natural disasters in the Constitution, it uses the word including, which says that even though it gives some examples of some disasters, there are others which could be included. And COVID-19 covered that, would have covered that. Moreover, we have the Public Health Act, which specifically deals with COVID-19 situation, because COVID-19 is a public health situation. And interestingly, the definition of emergency, the Public Health Act, is derived from and picked word to word from the international health regulations of the World Health Organization. And so that tells you that we had what we needed to be able to deal with the emergency. And what is interesting is that this Imposition of Restrictions Act, which the government brought into place by a certificate of emergency, did not reference COVID-19 at all in the whole of the document. Number two, when you are dealing with emergencies and you make laws to deal with such emergencies, the law is supposed to be a temporary law. It is not supposed to be permanent. It is supposed to last as long as the emergency lasts. But here's the situation where the Imposition of Restrictions Act did not have a sunset clause. So that means that even though, for example, some were saying that, oh, after all, the president came on air last weekend to say that the restrictions are over and so on. It did not wish away that law. The law would still have been there because the law doesn't have a sunset clause. Number three, that same law, the Imposition of Restrictions Act, has its own definition of disaster, which is fundamentally different from what we have in the Constitution, the Constitution's definition of natural disasters. And so that means that, and that law, that definition of disaster, if you look at it carefully, it is nebulous, unclear, untidy, just some words put together, and which therefore would lend itself to be subject to interpretation or for the government to decide at its whims and caprices what should constitute emergency based on the disaster that it will define, and therefore to go ahead and use that Imposition of Restrictions Act to do whatever it would want to do. Okay. More so, we look at Article 21, which was the basis for the law. The Constitution references Article 21, but Article 21 is not related to emergencies. It deals with limitations, and the limitation also deals with freedom of movement. But that law, that provision was used to create the Imposition of Restrictions Act, which was then used to restrict many other rights and freedoms. Freedom of education, schools were closed down. Freedom of cultural practices like funerals and so on, a whole list of them. But these restrictions would have rather been covered under Articles 31 and 32. And there are clear guidelines as to how to go about it. The president will make a declaration and after consultation with the Council of State. And then the Council of State, with the approval of the Council of State, it will go to Parliament within 3 days for Parliament to endorse the declaration. And within a certain time frame, if the declaration would persist beyond the time frame that Parliament had given it, the president will have to come back to Parliament for Parliament to extend the declaration. And there's the setting up of a body to deal with violations of human rights during the period, and many other provisions dealing with that. All these things were sidestepped. That is why we were concerned that this law could be used for some other purpose other than COVID-19. And therefore, we needed to challenge that and to ensure that the law is repealed, and we'll have our peace of mind when we sleep that tomorrow we will not have any emergency being declared anywhere, and then the people will be in panic, not knowing which way to go to, whether we're going back to Articles 31, 32, and so on, or we're still relying on the Imposition of Restrictions Act.
In fact, the outcome of your case is indeed a broad one, and it's for the greater good. But if you look globally, most countries passed laws to ensure restricted movement to prevent the COVID virus from spreading. So when this ruling came out and the Supreme Court sided with you about the unconstitutionality of this particular, the Imposition of Restrictions Act 2020, question is, then was this particular aspect also taken into consideration, where the original intent of this act was to ensure that we were all safe? And that's why these restrictions were put in place in the first place, where churches, funerals, and others, all sorts of restrictions at the time.
Well, like I'm saying, first of all, the law, when it was made, immediately it came out, we began to question it, and articles were written about it and so on. And during such emergencies, many countries, like we said, made new laws. In fact, we did a survey on a number of African countries to determine the human rights preparedness of each country towards an emergency. There were a number of countries that also came up with new laws, emergency laws, which were in line with their constitutions or derived from their constitutions. Others went outside their constitutions, like Ghana, and enacted new laws altogether. Some have been successfully challenged, for example, in the case of South Africa. And so what we perceived is that during periods of emergency, governments have the tendency to take advantage of such emergencies. We can talk about when 9/11 took place, and we had to tighten security, which led to a number of human rights laws being compromised in the name of national security. And some of these laws have remained permanent. Same with COVID. It's not only about the human rights dimension, but also corruption, because you had to be soft on the procurement laws and so on, so that you can get the PPEs in and so on. And there was massive corruption there in a number of countries, which some a scholar has even called it the pandemic of corruption, which is bigger than the pandemic of COVID-19. So when such situations arise, governments tend to take advantage of it. Now, what we're saying is that Ghana has a Public Health Act, which deals with quarantine and all those measures. Why didn't we use that first? And within that law itself, the Minister of Health also has the power to declare an instrument, to come up with an instrument that is supposed to deal with any necessary gaps. And so that is where we should have gone to first, before checking if there are still some gaps that we needed, in which case we could just still fall on Article 31 and 32 of the Constitution to fill the necessary gaps, so that we can deal with the emergency and governments will not take advantage of a pandemic of this scale and magnitude to exploit the situation, unfortunately, to the disadvantage of the citizenry.
I see. Well, I recall that at the time in 2020, when Parliament was debating and the process of passing this Imposition of Restrictions Act, they made reference to Article 21 of the Constitution, which allows restrictions to be put in place in the interest of defense, public safety, public health, or the running of essential services on the movement or residence within Ghana of any person or persons generally, or any class of persons. In fact, this law allows government to issue various instruments while health authorities also manage the COVID. You're saying that the strength of this Article 21 did not give government that power to do what it did?
It did, but what we're saying is that we could have done this differently according to the laid down rules, and it would have been done even better, and less violations of human rights would have occurred. Or even if they had occurred, there would have been the Articles 31 and 32 lay down rules where if you feel that your rights have been violated, even though some rights are supposed to be suspended during such periods of emergency, you will still have recourse to law to be able to get compensation for any harm done you which went overboard. But here's a case where instead of going through Article 31 and 32, we decided to go through Article 21, which doesn't deal with emergencies. In human rights law, we have a difference between limitations and derogations. Article 21, in there we have limitations. Limitations are permanently placed in the enjoyment of certain human rights provisions so as not to infringe on the rights of another person to also enjoy his or her rights. On the other hand, when we are dealing with emergencies, we are dealing with derogations. Derogations refer to human rights provisions which, because of the emergency, needs to be suspended temporarily so that government will have the free hand to deal with the emergencies that are there. And even with the derogations, there are some rights which are non-derogable. In spite of the emergency, for example, you cannot impose slavery or slave practices on anybody. And so these are the clear guidelines which our laws have. And moreover, we are a state party to the International Covenant on Civil and Political Rights, which also have clear provisions and recognizes states of emergency. That again, if you look at our constitution, it is largely in line with that. So why did we bypass all this and go and find our own way to solve the problem?
Professor Kojo Appiagyei Etua, thank you so much for your time and congratulations to you. It's an honor.
Thank you very much.
Great. He is an associate professor, School of Law, University of Ghana, and he, together with 8 others, dragged government to the Supreme Court contending the law on the Imposition of Restrictions Act, which was actually passed by Parliament, was unconstitutional. In fact, the Supreme Court, in this case as well, in a